Order, order. We are now in public session. Gentlemen, thank you so much for coming to give evidence before the committee today. Clearly, the bill we're considering has provoked a wide range of interest and some comment in the press. And we wanted to make sure, before we concluded our evidence-taking sessions, that we gave members of the press an opportunity to tell us about the bill and their perceptions of it and their views on it. We are very grateful. Now, although we know who you are, for the public record, it would be helpful, please, Henry, if you just said who you are for the record.
Henry Porter. I'm a novelist. I work as a contributor for The Observer, and I'm London editor of the American magazine Vanity Fair.
Thank you very much. Paul.
Good afternoon. My name is Paul, Heritage-Redpath. I am a solicitor and a product manager for an internet service provider called Entanet.
Thank you very much.
I'm Duncan Campbell. I've been an investigative reporter for 35 years, and I've also been an expert witness on communications for nearly as long. Over the last decade, I've extensively audited and tested communications and computer data in the criminal courts. And in terms of my journalism reports that I published in 1980 and evidence I provided to the European Court, were parts of the trigger for the Malone judgment, which led to the Interception of Communications Act. Much later on, I was the expert witness and instructed by your next witness, Keir Starmer, in the 2008 European Court case, that's Liberty and Others versus the UK. And that's a case I've made sure that a copy is in the hands of the committee because it specifically considered issues of filtering in the context of communications collection and analysis, and found the UK's practices to be non-compliant.
Excellent. Thank you very much. Well, our committee members will have a range of questions for you. Don't feel you all need to answer every single one unless you wish to. But again, do not be constrained and hold back. Mr. Wright.
Thank you, Chairman. Sort of gentle opening to the bowling, if you like, to ease you in at the crease. Look, the media coverage of this proposed legislation has been, I think you could say, unrelentingly negative. It's been described as the snooper's charter by many. Do you think that's a fair analysis of what's been proposed? Because we've certainly taken evidence where witnesses have said they felt that the media coverage in relating to this draft bill has been inaccurate. Shall I start? In any order you like.
Well, I do think it's fair, because I think it's a very bad bill and it threatens the very foundations of our liberal society. And if you come from where I come from, which is that the profound belief in our democracy and the ways of a free society, you see this bill as a very great menace to it. And so even if the coverage is unrelentingly against this bill, I don't think it's necessarily unfair. And the second point I'd make on this is that we have to hold government to account. Now, the media is often coming in for a lot of flack itself. The BBC Today, journalism, newspaper journalism throughout this last summer and last year. But the fact is we still have this important job to do. And it will make it a great deal more difficult to do this job if sources in Whitehall, sources in politics, in big companies, can be traced, their communications can be traced to journalists. So that is another reason, and perhaps the sort of secondary reason, why the media is probably very against this bill. But I would say that the first reason is that it is hostile to the sort of society that we have now.
I find it difficult to hear the Home Office complaining of unfairness when what they're putting forward to Parliament and this committee is something that's really been stewing around for at least 10 years, been pushed forward in various ways, and yet when they come here, or the witnesses come here, it seems that no one in the telcos actually knows what they plan to do or how they will implement it. I was also gravely concerned that Mr. Farr, in his evidence and within almost his first interchange with Mr. Ellis, completely misled the committee about the situation with communications data. I put a note in to expound on this should it be necessary, but the statement that 30 years ago BT was collecting communications data and the implication that they were now not making that sort of information as available was the exact opposite of the truth. So extremely badly informed, passing on poor information, and actually misrepresenting the situation as it's seen now in terms of the amount of information that is actually available, which has been increasing as devices become available, increasing as new forms of data, for example, location and cell site analysis come into the system. So I see this Home Office as having misserved itself very badly from the very title of the presentation of the bill, remedying a gap. No, they're not. They are increasing, perhaps for cause, perhaps proportionately. There are things which could be done, areas that can be addressed, but they've led themselves wide open to this accusation of the Snoopers Charter. I wouldn't quite endorse that title yet, because what they are creating, if Parliament were to give them the powers in this form, would really be a universal surveillance engine attached to the mass or all of the British internet. Now, what you do with it, whether it does become a universal snooping engine, is withheld from us, because none of the orders, none of the codes of practice, none of the facilitating instructions, some of which may come to Parliament, some which may remain classified, are before us. So again, given the degree of obscurity, the surveillance engine could be the Snoopers Charter, or it could be reined in. I would just finally say that the important point of human rights, which seems to have been overlooked in the way the bill was drafted, has been formed. It has been formulated for us by the European Court, and really supports the apprehension that perhaps is seen as coming too stridently from some journalists. The mere existence, and I'm quoting now from the judgment, the mere existence of legislation which allows a system for the secret monitoring of communications entails a threat of surveillance for all to whom the legislation may be applied. It strikes at freedom of communication between users, which is Henry's point, and I would absolutely and strongly endorse that for the special case of journalists seeking confidential sources and secure communications to them when those sources act and come in the public interest. And the court finally said, it is therefore, that is to say, the mere existence of legislation of this type is an interference with Article 8 rights, irrespective of whether there were to be measures taken against an individual person. So that's a very powerful, legislatively backed, long-standing in the European jurisprudence that really does go to help understand why epithets like Snoopers Charter have had widespread currency.
I would say that the newspaper coverage has been, if anything, relatively balanced on this issue, because this is something which strikes at the heart of human rights. And I don't think the Home Office have done themselves any favours in the way that they have presented or engaged with it. And I think their newspaper coverage has been limited by the fact that it's actually quite difficult to articulate to the public what lies behind this bill, and I believe that that is a deliberate intention. As a communications provider, we have had no contact from the Home Office. As a member of the Association of Communication Providers, we invited the Home Office to speak to all of us collectively. They spoke for half an hour, and they told us absolutely nothing more than you would find in the notes of the bill on the grounds of national security. Now, this is something which strikes at the heart of how we operate as an industry, and I think the fact that they won't articulate it to us means that the press articulating that to the public is very difficult.
So your view as a panel of witnesses would be that far more groundwork could have been done by the Home Office in terms of background detail. I mean, one of the things we've struggled with as a committee, Mr. Campbell, relates to your point really, which is about understanding what lies beneath this legislation, what will come to Parliament at a later point.
Yes, I mean, I can address it both as a journalist and I can address it from the bottom of the pile, if you like. What is it that my police colleagues would like to be bringing into court that they could get from communications data that they don't now get? There are relatively few things, given the richness of material from other sources, and many of them, if you take, for example, can we go to Skype? It's been laid out that there is a completely alternative route for going to Skype, so we don't need to worry about Skype in this context. Yes, they've also eschewed looking at things that could be simply explained to Parliament and public. Way back, 12 years ago, we were working on Chapter 2 of REPA, and soundings were taken, views were expressed as to how you proportionately apply the surveillance of weblogs. And Chapter 2 of REPA does provide some powers, but it's never really been put into practice. Now, since the new provisions, excluding the additional filtering requirement, necessarily embrace all of that, that whole debate could have been laid out in the open. The Home Office could have briefed on it. They could have addressed the arguments that were put for both sides then, expressed a position, allowed Parliament to take its view, and so on and so forth. So they've missed a lot of areas where, without needing to have recourse to national security considerations, they could have been open.
Thank you very much, Lord Strasburger. Question 3.
Right.
Well, perhaps if
I was going to ask you, actually,
yeah.
why do you think the Home Office have got it so wrong?
To me?
Yeah, anyone.
I think that they have insulated themselves too much into a very small group that really only essentially talk to themselves and a few others, a few key engineers, and not sought to access even perhaps their own ministers in getting an understanding of what might be required and what might be developed. They're operating in too small a world. I went myself to one of the Home Office briefings a couple of years ago when we were looking at the previous bill, and asked them to sort of try and explain some simple points. And they struggled. They didn't seem to know their brief, and they didn't seem to be very enthusiastic about then learning their brief. It was very disappointing.
Speaking as a member of the public, there was an extraordinary self-assurance about the presentation by the Home Office to us of a from high to low basis. We have decided this is in the best interests, and we're not going to tell you what it is, but you'll just have to believe us. And that was really how the Home Office presentation, at a quite senior level, came across to us.
Okay. Yeah.
You said in your opening remarks, Mr. Campbell, that there are areas which could be addressed. Now, yes. Now, it'd be helpful if you could elaborate on those.
Yes, well, first of all, I've referred to weblogs. Now, Internet subservice providers do not routinely obtain a log of what happens when a user, any one of us, is using our browser. And in fact, a very rich trail of information is generated, many entries per page, both on your computer and for a certain time would be held by the communication service provider. So a step that the Home Secretary could take is, by order, to have that data held. It would be huge, it would be difficult to process. But we all know what it is. It comes into the courts every day because it is also found on suspects' and defendants' computers. So it's a kind of evidence that need attract no secrecy. The businesses do not want it because beyond, say, a few weeks to do an engineering study of whether your server is working, you absolutely do not want to store that kind of data. But there need be no secrecy about those kind of records or how they might be filtered or how might they be used. And indeed, the previous debate on REPA addressed that. I think Professor Anderson's evidence also covers some points about that, probably Professor Summers too. Then there are those areas where the solutions either cannot exist realistically or obvious. The Information Commissioner mentioned virtual private networks. I would agree with that. The problem of Tor, if it's a problem from the point of view of UK law enforcement, but although I didn't put it in my CV, I go and work for the other side on occasions in that respect, bringing the knowledge of what you can hide, and that I've done quite specifically in support of the Syrian insurrection and people who are struggling to overthrow the Assad regime. And of course they have high dependency on Tor, their lives are at risk, and if this government were to, by some way, and I think Tor would say it's impossible, to make that not available to them, we bring about a far greater deficit in human rights in other parts of the world. You've got things like Skype, which have set out a model which works if you address the Mutual Legal Assistance Treaty things. And I've seen product come into the courts from MLAT. It's effective, it's what you'd want, it's the communications data that's asked for. So all of that is not being considered.
That MLAT is a bit slow.
I've never seen MLAT work fast, but I think already comments have been made as to the way the Foreign Office could be encouraged to speed that up.
Okay, thank you. Lord Strasbourg, sir.
About the request filter,
Yes.
is it the case in your view that the distributed database that this bill foresees, combined with the request filter, is going to be any different from the centralised database that was proposed in previous legislation?
It appears to be larger, notwithstanding that it's distributed. I say that because the centralised database would ingather the communication service providers' records of the specified times and hold them nationally with, no doubt, automated access. But and that is required to come into being by the first part of the bill. So basically you have the national database within the bill anyway, save that it will be held in this model by the CSPs. You then layer onto that the DPI devices that will hang on the key points of the United Kingdom network and mine unspecified, as yet unspecified classes of data, presumably into similar local databases, but they will, by their nature, have to be integrated nationally, and I think this was conceded by the Home Office witnesses. You're going to data match across things that you see in the content derived from different nodes on the internet with different companies in order to try and get a match to generate communications data. So if that analysis is correct, this is the national database of the previous scheme plus the additional databases supporting the need to retrospectively look at, I would imagine, a year's data taken from whatever the filtering system turned out to be. So a bigger database.
Yes, if I may address the committee on the request filter generally. I think one of the challenges in the discussion around this debate is that it goes to technical matters and there's been very little technical discussion. The web is ultimately ones and zeros and they are aggregated up into chunks, and those chunks may or may not have some meaning. Now, from the point of view of the request filter, we can see that use of the web is continually increasing. So the database that we're talking about, even if you take a year's slice, is only ever going to get bigger. Wherever that database is housed, it will require space, cooling, power, maintenance, and people. And even if the Home Office pay ISPs for those things, that affects how you run a business because you have to allow for somewhere for that database to live. It also means the more people and the more data is involved, the more risk there is of human nature going in and having a look. And this would be an extraordinarily large database. Keeping it secure would be, in my view, almost completely impossible. Easier from a technical perspective than a simple who is able to access this data perspective. So from that point of view, it is a huge, huge risk. And I speak as somebody who looks after data centres and looks after ISPs. There is also, and it's unfortunate that we all have to speculate because we don't have clarity on what is intended. I think, as I and others have read the idea of the filter, it is Google for a set of databases that have been collected about traffic, so it can make connections. Now, on a very small scale, something similar has been tried recently by the Motion Pictures Association of America and the BPI. They looked at about 13,000, so a small sample of requests where they thought traffic looked like people infringing copyright, and they used an automated filter to perform that exercise. In 16%, the actual addresses of the infringers were ones that were inaccurate, either malformed or not the right people. That's a very small sample. Now, that is just sending letters about copyright infringements. It's not going to ruin anybody's day too much. But if we scale that up to everybody's communications all the time and have that sort of error rate, or even a very small error rate, then the risk to human liberties is significant. And I would ask the members of the committee to think, when you do a Google search, bearing in mind that Google have the best engineers on the planet working full-time on search, how often, when you enter a search term, do you get a single correct result? You get many results, and sometimes they're right, but getting a single correct result? So if the idea of the filter is to say we have aggregated traffic from all sorts of providers, and we're then going to run a filter, what are the odds of that filter actually being 100% accurate? And even if it were, what is the use to the Home Office when they go before a court and say, I have evidence, but I can't tell you where it's come from because all I've used is a filter. I don't know what the filter's filtering, and I don't know if it's got it right. So from that point of view, just as a common sense view, I have real problems with the filter.
Thank you. Mr. Porter, anything else to add?
Yes, I would just add that it would be lovely if we could start using plain language here. This is a search engine or a data miner. I had to scurry around. I'm not obviously as technically expert as these two, in fact, much, much less so. But I had to scurry around and ask for an explanation for people who do understand these things, what it is. And what it is a data miner. So let's call it a data miner, which makes very, very fast connections between numerous sources of information. And the fact that this is not in one silo of information, doesn't make the slightest bit of difference. It is giving access to a small group of people to a massive amount of power. And when we talk about this filter, we're talking about computing power. And it's computing power which is increasing with an astonishing acceleration every year. Our ability to do things tomorrow which we couldn't do today is really extraordinary. And so this bill, apart from anything else, should take into consideration the massive power that will be given to these people who are running this system under the communications data silo, or whatever you'd like to call it. So I would just warn that this is, not power of today, but power of tomorrow. And who's going to be in the government, who's going to be in charge in the civil service? These are the things that worry me, the non-technical expert.
Thank you. Lord Steinberg.
It's for Mr. Campbell specifically. Back to the filter. We've had evidence querying whether the results from the filter will meet evidential standards. If you were working with Defence Counsel in a case that relied on filter results, how would you go about questioning the admissibility of evidence derived from the filter and the weight to be attached to it?
Lord Strasberg, my expectation is that the courts would probably never get to see that kind of information that was passed out of the proposed request filter. I'll explain why that in a minute, but the obvious point that goes to is how useful can this really be for prosecutions? The evidence given specifically in the UK Liberty versus UK case was that we're not going to discuss filtering. It's too complicated, you won't understand it, it's all classified, we're not going to reveal our methods. And the main reason for doing that, I suspect, is that the driving problem that they never quite admit until they came here and said we're never going to get 1 in 6 communications is that they don't want people to figure out what it is that they can't get, because fairly obviously the bad guys will navigate through that. So their clear position in Liberty versus UK was that they don't want to explain how filtering works. And they're trying to protect not their strengths really, but their weaknesses. If I was wrong on that, I could be, then the admissibility would depend on the way that the court would approach testing. For example, an assertion from the prosecution by its experts that our filters had shown that somebody calling himself Santa Claus on a certain network was in fact an individual they could identify and had in the dock. They would have to be prepared to disclose, in that case, the details of their filtering processes, which communications internet providers they were taking it from, how they were pulling down the data, it's the phrase they used in Liberty v UK, and say how they make it a match. And then it gets worse. Obviously, if one is instructed for a defendant who contests that match, it will be necessary to do an audit trail according to the recognised standards of computer evidence in order to see what the parts are that go to make up that match. It may be statistical, it may be quite complex, and Defence Counsel will expect, and the judge will expect, that the prosecution, before bringing that evidence, will consider whether there's an alternative evidence that you would wish disclosed, or at least to consider you had to disclose in order to protect the rights of the defendant to due process. These are the obligations under SIPIA and the Attorney General's guidelines. The defence, through the court or otherwise, might quite properly wish searches to be done of a more extensive sort. We would put in our own filter requests and get yet more pieces. You can, I think, start to see that to add to the existing complexity of computer data cases from which judges quite reasonably resile if they have to instruct juries, you have an immense porridge of bits and pieces gathered from around the network, which an algorithm written by one company for the government says Santa Claus 87% probable to be Mr. Hoskins, for example, and on the other hand, an alternative analysis that says you haven't got a case, that you've identified this person. There is also the problem that if you go back over the implementation of REPA, they haven't really stuck up to evidential standards. Early on, we did have issues about whether the computer data, and it is computer data that comes through in response to Chapter 2 requests, subscriber, calling bill data, cell site data, and so on, should be produced and handled to the same standard as the police handle normal computer seizures, which is generally extremely good. That was lost before the courts, but the proposition that was endorsed by a judge in an unreported judgment and which came to be adopted was that there should be a golden or certified copy of original data as it was obtained by the service provider, as it was supplied to the police, and it would be retained in the in the custody of the communication service provider. Now, that was used as a phrase for standard practice, but was never understood. And for many years, although I think it has ceased now, the Spocks would deal with this by sending back their email to the communication service provider. The communication service provider's staff would send a statement back saying, we recognize this as being the kind of data we use in our company and think that that was good enough. So we've already seen those kind of problems in the way that the Spocks worked in the first decade.
That was quite a long answer to a short question.
I'm so sorry. I apologise.
Could I just try and distill that back and
Yes.
see if I've understood you correctly? You seem to be saying that because the authorities are unwilling to disclose the mechanism behind the filter, it's not possible to validate the effectiveness of the filter, and it's not possible, therefore, to put the evidence that falls out of it before the court in any meaningful way. Is that right?
I believe they would not produce it in the first place because they would foresee the technical difficulties and the issues of that which would...
Thank you.
Whatever other use the security service or the police could make of the filter, using it as evidence in court is unlikely to be one of its main functions.
On the basis of as much information as we have as to how it would work, which is, of course, little, that is my view.
Thank you very much. Yes, Lord Faulks? Yeah.
Just one thing, perhaps you can help me with, Mr. Campbell. We got a letter from the Director of Public Prosecution suggesting that some of this evidence previously has been admissible as business records hearsay.
Yes.
In your capacity as an expert witness, are you familiar with this concept?
Yes, that's correct, and what he says is correct.
Thank you.
Mr. Ellis.
Of course, it's right, isn't it, though, Mr. Campbell, that very complicated evidence, including of a forensic nature, perhaps cell site analysis, is already produced in court on a regular basis. It doesn't seem to hamstring the courts in producing relevant and admissible evidence of a modern type.
No, they
can handle it, can't they?
The use of cell site evidence has become increasingly established over the last 15 or 16 years. It has a degree of technical complexity to it. it is generally reduced to maps.
Yes, but
and
usually
put in a form that's...
Yes, so cell site analysis, which is the location of mobile telephones. So usually the parties in court would stipulate or agree between themselves that the evidence has been obtained in a certain way and make an admission to that effect so that the jury were not troubled with unnecessary complexities.
Yes, the courts always admire a situation in which experts for the two parties seek to agree as much as possible and then precisely distill down that on which there is disagreement and on which the jury should
That could happen in
adjudicate.
the instant case, couldn't it, in the case we're talking about? It wouldn't need to necessarily be explained to the jury in finite detail how everything happened, how scientists obtained DNA from a sample of blood would not necessarily have to be explained, but merely the bare fact that the scientists have come to the conclusion that the DNA within blood is that of the suspect.
It's axiomatic that if the experts advising each side agree, then there is only a single joint statement to come before the court, which the judge would normally accept. In the area, and I think I gave a perhaps over-detailed answer to Lord Strasbourg, in the area where the filter comes through, and I speak from a shared ignorance of what this filter will really be when it turns up and what the database will be that it applies to. But you are going to ask the simple standard questions that you would ask representing anyone. Where did this come from? What are the component parts? What is the means by which it is processed? And how do you reach the conclusion that you've told us you reach? And if there's going to be a dispute, and trying to foresee the kind of evidence that you've got here, there will be a dispute as to how that could be reached and whether it was valid. And it would be massively complex.
So do you accept, gentlemen, that, if I can just take a step back, do you accept the premise that there has to be a legal means for interception, or in this case, data communications? Do you accept that to defeat the ends of terrorism, serious criminality, paedophilia and the like, there has to be a means to do that?
Shall I start?
Yes, please.
Yes, I do. But I believe in targeting the people that you propose to prosecute, the people you believe to be criminals. I don't believe that this entire nation should subject itself to a massive surveillance campaign by a few people who appear to be unscrutinised, the methods untransparent. But I certainly think that we should have these powers, and we do have these powers.
And have had them for many years.
Absolutely, no contest. And there are, 500,000 of the interceptions now per annum, roughly?
Yes. Of course, we should emphasise, of course, that this bill does not deal with the interception as such of content. This is a different matter. This is not something that is seeking to read people's emails, which has been an aspect of the misreporting that I'm sure you'd all agree has taken place.
Can I disagree with that?
You disagree with that?
Yes, of course, the bill lays out the difference between content and the data of the communication. But the fact of the matter is, we all know in this room that the data surrounding a communication is as useful and can lead you to the content of that communication, and so that the difference is very much a spurious one.
If I could address the point, and going back to DNA, ultimately with DNA you have a physical sample. You may disagree about how the analysis has been done, but you have something which is repeatable. With digital evidence, unless you have an audit trail of how it came to be all the way through, there is the possibility that somewhere along that way somebody may well have tampered with it.
Yes, but Mr. Heritage-Redpath, you need the audit trail as well with DNA or other forms of evidence.
Quite.
So you need to be able to say that blood came from X person. You couldn't just magic up the sample and say it matches the defendant.
Quite. But what I'm saying is that in the case of all normal evidence by which the police force have done a splendid job for many years, they have targeted it in a particular case. What we're talking about here is something entirely different. We're talking about capturing, let's say on the face of the bill for the moment, capturing data about all communications, lest it might be necessary or helpful at some point over the next rolling 12 months. That's a different thing to a targeted investigation. I don't think anybody on the panel would argue
you accept, do you, that there needs to be a legal means for police and law enforcement agencies to lawfully go about this type of activity.
Oh, entirely.
You accept that fundamental premise?
I do, and I
and
think
if
the
you
way
do,
the Home Office has sold this bill is that everybody accepts the fundamental premise that we should have the means to combat criminals.
Right.
But it is not then a stage to say, having accepted that,
well,
just
but
sign this bill off.
Do you and your
things.
colleagues also accept, if you accept that premise, that the legal means have to keep up with modern and novel methods of communication? So, if it is lawful and has been for decades to intercept, for example, landline telephones, do you accept that modern methods of communication can't be simply ignored, because criminals will use those modern methods of communication in order to defeat the ends of justice?
There was a time, of course, when there was no law on interception of communications. We, the press, I, the press, and in a large measure, pushed that into happening, and I do take pride in that.
And congratulations.
And thank you. I hope sincerely meant.
It is. I try and say everything sincerely.
I completely agree with what you say. Of course, it is fit, proper, and necessary that interception of communications and processing of communications data be available as part of the armoury to combat all the things you have mentioned. That is not my problem with this bill. My problem is that it's not fit for purpose, it's not been thought through, and it isn't going to work. Leave aside the human rights issues, right? Proportionality and necessity, right? We are required to test that. And in this forum, we're also required to test value for money and technical efficacy. Now, the witnesses who came here on the first day said to you, we'll spend all this money, and by 2018, 1 in 6, 15%, roughly 1 in 6 of communications that we would like to get, we will have no data about. Now, that is a huge amount of gap, which is on their own evidence not going to be remedied. Where that data came from, we don't know, where a service assessment it is, but that simply raises the question of whether it is even achievable. And, of course, it's not achievable to get everything. Our police forces, our security services are doing the best jobs they can. Yeah. They're going to get it wrong sometimes. There's going to be some dark areas. Right. So once you've accepted, as I accept your premise, as I must, you must also, I would accept the other premise that there will always be the dark areas, and that therefore the proper area for debate is fitness or proportionality, necessity given the other types of data that can be used in investigations, technical effectiveness, can it work, cost efficiency, and then all the human rights criteria, the fact that you do terrify people by creating powerful laws.
But on the technical efficiency aspect of that, and the other aspects that you mentioned, therefore, you don't think the bill is strong enough?
No, I don't think the bill is capable of getting to 100%, right. And it overlooks.
But nothing can get to 100%, can it? In all seriousness, we can't arrest 100% of burglars. We can't, even with fingerprint technology. We can't do that. Yes. So we can do the best that we can do. Could I just ask you, gentlemen, on this point, which is the necessary and proportionate aspect, because the bill envisages that any request for comms data would be necessary and proportionate. It's a safeguard written into the bill, and that would be verified by a senior officer. Now, we have and have had for many years aspects of our civil liberties which are affected by the opinion of senior officers. So, for example, within the 1984 Police and Criminal Evidence Act, a superintendent has the right to extend detention before anyone is charged in a police station. An inspector, chief inspector, can oversee ID parades and the like. So there's a safeguard there that we're used to in the English criminal justice system. So do you not envisage that those safeguards can apply equally well here? And if not, why are you worried that they won't work here when they've worked for decades elsewhere?
Like me to go? Well, the first thing I would say, let's just go, I hate this idea of self-authorizing this sort of power to one individual. One individual may act in one way, another one may act inappropriately. But what I want to see is scrutiny. I want to see how this process happens. And I would love to, I personally think it should be in the public domain, that these authorizations should take place in public. After all, we're talking about a democracy, which is a fragile democracy. If you look at what has happened over the last 10, 15 years, we had an ANPR system pushed through the country, cameras recording registration numbers everywhere, on every motorway and through every town centre. This happened without even Parliament granting the money. It happened because ACPO decided that it should. You have CCTV cameras being enabled very gradually with face recognition technology. You have CC cameras in schools, in cabs, in trains, in pubs, in restaurants. What I'm saying is that this is part of a very, very serious move towards what could easily become the structure for a police state. So let's just go back to the authorization. The police aren't perfect. They have misused ANPR information to track legitimate protesters. There have been occasions revealed during the Leveson inquiry where police officers have accepted money to give journalists information. To say nothing of the misuse of the police national computers. Now, I want to see, I just do not think this power should be just given to the police. So I'm not as happy or content as you are about the way that might happen.
Well, we need to move on. Yes, forgive me. So just if there's any briefly comments anybody else wants to make on that.
In response to your question about senior officers signing on necessity and proportionality, that's necessary, but it may not always be sufficient. I think, and some witnesses have put forward, that a much better scheme would be a multi-level surveillance authorization, which to some extent already exists in terms of intrusive surveillance, and that should be applied to the communications data schema, so that you have a signing off at higher levels or a warrant from sufficient authority, depending on the degree of intrusion involved. But these are the appropriate and necessary processes. Just two minor points. Although it was not required by law, the police sensibly adopted a scheme whereby assistant chief constables would be required to sign off on location data requests. They've dropped that now, but they saw the degree of intrusion necessary and they said, a chief superintendent's not above, we'll go to ACPO rank. The other point I would make is that the European Court has required that the procedures for examining, using and storing gathered communications material should be in a form which is open to public scrutiny and knowledge. And along with authority, that's an important part of the process.
Thank you, Lord Chairman.
Lord Jones or Mr Brown, did you want to come in on a point here?
I'm quite interested in moving this on to the point about safeguards. I mean, as you rightly pointed out to us, this is a framework bill, and once the framework is agreed as primary legislation, the flesh on the bones will come as secondary legislation, and the opportunities for Parliament to say no or pause or think again are strictly limited. So it is important to us that we get this right. I'm interested in what sort of safeguards we would insist are included. We have given some thought collectively amongst ourselves to whether or not this point, Mr Campbell, that you referred to about multi-layered authorisation scheme, I mean, that is there now, but whether it would be possible to extend that. And in particular, I wonder if you could say to us what your thoughts are on the idea of a judicial element to the proposal, the magistrate's warrant that is proposed for local authorities. Should that be extended? Is it the right idea? Is the specialist authorising officer a better or a weaker safeguard than a magistrate who is independent but might not be as well informed or as experienced? Might be in all of the police.
They all get it right much of the time and wrong some of the time. I think a multi-level review of this whole area would be very sensible, and that taken within that would be escalating ranks within a police force or a security or intelligence service through to stepping outside to magistrates, district judges, as might be appropriate to the degree of surveillance. The situation is that this business of content versus communications data is a shibboleth from the 1980s, when, you know, we had plain old telephone service and clunky things called printer meters, which could occasionally be attached to lines. Now, without going into the desperate technology of it, I think witnesses have told the committee that the internet comes in layers, that the first layer is a communication, but the content that's sent contains communications data about the next layer, and that content in turn contains communications. It all dissolves when you actually look at some of the very complex things that operate on the internet. And it would be quite appropriate just to review how distinct content and communications data really are as part of an overarching review. I know it's been a well-tested argument about actually bringing intercept data into the courts. I've seen it, I've worked on it when it comes on from overseas jurisdictions, and it's very hard to understand the degree of resistance except a sort of primal fear of letting the adversaries know that we can't do some things. But so you could really quite usefully do an overarching surveillance scheme with officers of different ranks, judges of different authorities, and a surveillance commission that would act as the check and balance on whether the wide remits on all fronts had been followed.
That term, a surveillance commission, you see that as a separate body and not a slightly enhanced role for the interception of communications commissioner? Do you see there having any role in that?
I think debates here and elsewhere have pointed to a need to really enlarge the scope and indeed independence of the commissioner or whatever might be the successor body.
Thank you very much. Mr. Brown, you anything on question 9?
Well, I'd like to just to elaborate on this. How far is a magistrate, a separate magistrate, a safeguard? And is there any further safeguards to be gained in restricting the number of authorities? The bill only applies to the police, the security services, and so on, although it's clearly shaped in such a way as to allow other authorities to be added in later. And indeed, there's hints as to which authorities, including local authorities, the Gaming Commission and so on, will be added in later. Do you think there is any safeguard to the public in restricting the authorities that should be added into the bill?
Yeah, well, I certainly do, because if you look at the way REPA was abused in the first half of the last decade, I mean, you had punt operators in Cambridge, a woman who applied to a school in Poole, Dorset for her kid and thought to live outside the catchment area. And I think you even had eel fishermen in Poole Harbour being subject to a major surveillance operation. So, can I say, the predilection for abuse, you know, we are not a naturally democratic country sometimes, and people will use these opportunities to use their power to in an unpleasant way to their neighbours and to the people there.
Disproportionate way is what you're really saying to us.
I indeed was going to say that. But so, yes, I do think we should restrict as much as possible the number of authorities, and I think the maximum amount of transparency in the process that goes to authorisation is absolutely vital. And one of the problems with this bill is that it's not very specific. So half of us don't know. Duncan's been very eloquent in saying we don't really know what we're talking about because it's non-specific in so many areas.
Well, being in trade, I'm required to make a business case for any investment that we do. And if I made a business case like this, I would be sacked because we haven't been clear about what it is we're trying to achieve, how much it will cost, or how to do it. And the justification on the face of the notes, as Michael put it, was this is all about catching criminals. Now that narrows down what you're doing, but actually you get to the end of the bill and it says, oh, and by the way, here's a list of X hundred authorities who might be interested. So in terms of proportionality, if it were just crime, we'd be having a much more targeted and productive discussion.
Can I make one point about crime? I mean, crime is on a steady downward trend, whatever the economic circumstances of this country. Steady, 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 goes down. For the last 20 years, I think it's down 27%. Last 12 months, 6%. And yet, we constantly be told by politicians that we've got to guard ourselves against this terrifying society we live in. I mean, one of the main planks of this bill is to fight crime, but let us just look at what's happening out there. We are a very law-abiding society, and we're getting more law-abiding.
What are the public, our constituents, as well as your readers, are worried about is that something they have done is going to be on the internet or some communication, some bit of their private life they don't want their friends and neighbours to know about, is going to be discovered by a snooper and exposed in some way. How best could we safeguard against that? I mean, these are innocent people who are entitled to their privacy. How should we ensure they get it?
You're talking to me or?
Any of you?
No, please. Well, let's not have a vast database with large amounts of information in it. That's one way of guarding people's privacy. The second way is not to collect that information in the first place. I have a great problem with the argument that because people give so much away about themselves on social network sites or to Tesco's or to whoever, that the government and the state have a right, therefore, to take all that information and put it into a database. If you've listened to Ross Anderson, the professor you had earlier this year to give you evidence, he would tell you that there is no way that you can have a database which is at the same time large and secure and functional. So, and that means that actually once your constituents' information is in a big database, it becomes much, much more vulnerable. So my answer is don't have this bill. I mean, it's very simple. Mr. Ellis has made very good points about targeting criminals, but I mean, to collect this massive amounts of information on people means that it one day will become vulnerable, maybe to a journalist at News International or a detective working for News International. This is the point. Once you have these databases, they are a treasure chest.
It is an obvious concern indeed. In auditing sport data down the years, I've always had it in mind to watch for an extra one being slipped in to bung to a journalist. Haven't found any, but it may be that Lord Levinson and the associated police inquiries will be leading to this in due course. Mr. Brown's point about the sensitivity of data and the risk it could leak would, in my view, flow largely from creating this database in advance, so these databases that are required. And again, rather than the obscurantism of the Home Office approach, we can address this quite specifically in the case of weblogs. In my expert capacity, I have to look at weblogs, which when seized from computers can sometimes go back years and years, and frankly they terrify me. The intimacy with which you can see what somebody is doing, what somebody is thinking, you can infer when their attention is strayed from their partner to some other prospective sexual target. It's written there to be seen. Now, if that person is under that degree of surveillance because their device has been seized by the police, because of a suspicion, then you can at least see how that comes about, and the rest of the population can be reassured that that is never going to come to pass unless officers do come through their door for whatever reason. If you move to what was envisaged under REPA, and which will be reconstructed here, then at the very least the big internet service providers are going to be asked to store that kind of data, although we have no clue as to the depth of knowledge, that degree of intimacy. And that means that if anyone wants to go on a trawl, whether authorised or unauthorised for a purpose might be approved or for not, they can trawl to see who's been accessing special clinics. They can trawl for who's been going to particular websites. They can trawl to draw up profiles and demographics just in the same way as Google does. Clearly, most of all of that would not be proportionate. How do you stop it? Don't do it in the first place. Stick to what you get on people's computers.
Thank you very much. Lord Jones, did you have any other points on safeguards, or has Mr. Brown covered?
Progress, Chair.
Right, okay, excellent. Thank you very much. Mr. Hubbard, was it? Yes, Mr. Hubbard.
Very much enjoying the comments you've made so far. It's been a great pleasure to listen to. Can I look at some of the issues to do with parliamentary scrutiny and what is envisaged within this bill? You've all expressed concerns about the, I guess, skeletal nature of the draft bill. For example, Clause 1, which, to paraphrase slightly, says the Secretary of State can by order do anything she likes. Do you think that is inappropriate, that there would be a system where you have this primary legislation, there's then an order which is essentially unfettered, which provides then for notices which nobody gets to see? Does that seem like an appropriate way to take things forward?
It seems mad for a democracy to even be considering this behaviour. I mean, I'm amazed we're in this room actually countenancing this legislation. We've all brought ourselves to a point where we feel it's necessary to think in these terms, but actually if you step back and you think this is, well, imagine what Wilkes would have said, or any of the other great men who've been responsible for fighting for this democracy and the liberal free society that we have. Imagine Wilkes listening to you now and saying, well, these notices would be shuffled past, nobody would take any notice of them. It's unimaginable that we're even considering this. I used to go, when in the last government, go to select committees to watch one or two of the bills being discussed. I was astonished that we were even thinking it this way. It was a thing called the legislative and regulatory reform, or some mad scheme where you could...
Abolition of Parliament Tax.
That's it. And, sometimes when you just said that, I think, how can we countenance this? We must be thinking of our democracy in different terms to the one I was brought up with. We have to sit on this bill. I don't care what party anyone comes from. This bill is dangerous. This bill is really, really dangerous. And if we let it get through and it's vague in its current vague terms, and then things are just added on, nobody pays any attention, we won't have a democracy.
And we're all responsible for public money at the end of the day as well. We're all responsible for public money. I was involved in the e-conveyancing scheme with the Land Registry. This was a scheme where industry were consulted, where the people who were involved were very clear about what they wanted to achieve. There were very tight, small objectives. It was £11 million of public money, and it never came to fruition. I don't know anybody in the industry who thinks that this scheme can possibly work. And to use a very layman's analogy, I think we talked about telephones before, and Duncan, in his last piece, Duncan said about weblogs. To be very clear, Duncan meant, I think, just the record of the URL that somebody had gone to, not content, just communications data. Now, the way the internet works, and the way ISPs work, is we try and move information around as fast as possible. The last thing we want to do is look at it and to try and make sense of how difficult this would be. What we do is akin to a traffic policeman going this way, that way. What the original scheme, the old scheme of the Great Centralised Database, started off by saying, actually, that traffic policeman will say, stop, each car, I'm going to ask the address that you're going to and jot it down. And you can see that will not fly. So the new improved scheme is to say, well, okay, we will just channel all of the internet and keep it, while it's going past, we'll just keep it for a year on a rolling basis. Again, just common sense. How is it possible to get the capacity to do that, even if you agree that that is a good thing to do? It's just like trying to pick the M25 up and photocopy it as it's going past. You can't do it.
That is a concern with the filter. There is no detail, as ever. We start from ignorance, but it's, to my mind, inconceivable that the tasks anticipated for any filter could be done on data as it streams past. And therefore, what you are left with is the elephants in the room that surround this bill, which is we mustn't call it a national database because that's what the last government did. And therefore database is avoided, but in fact database is essential. I fear the Home Secretary has not been well served by her officials in this. One isn't privy to what goes on, but the sense is, don't worry about this, it's all techie stuff, you really don't need to know, Parliament doesn't need to bother its head, it's the big complex internet, we'll sort it out. And even if it wasn't this very sensitive area of legislation and important area of legislation, what you look at with any knowledge of larger public sector IT projects is massive expenditure, billions of pounds, on a future that is untested, on technology that seems incapable of being specified, and which hasn't been described to the people whose equipment it will attach to. Let aside all of our other worries, the total gap in the information about how this will work means that there must be a very high probability that this will become yet the latest public sector massive cost IT overrun boondoggle.
We need to conclude.
I'll try and
move on to the last question.
Yeah,
please,
indeed.
Mr.
Thanks. I mean, the officials will have a chance to speak. They're coming back to this committee, and it's certainly a frustration of mine that we haven't seen the draft of the order at all. The Home Office position, if I try and paraphrase it for making it so broad, is that there is a fast pace of technological change, and that they want to have a bill which is future-proof. I think that's the position. Given that we do believe that there is a role for communications, a legitimate role for communications data, how would you structure something so that you can resolve this? Would you have a series of bills with sunset clauses? Would you have legislation which was extremely precise and needed replacing on a regular basis? What do you think would be the most sensible and practical way of getting the benefits of communications data without the harms?
Well, first of all, I think if you're going to give this power to the police and the security service, you have to have a period when you say, well, is it working? Is the scrutiny working? What effect is it having on our society? Is it having a chill on our internet and web industries? Is it having a chill on journalism? So definitely, you need to review it. If this is going to go through, you definitely have to have a sunset clause or some moment when you say, yes, how has this affected us? Let's not just let it drift into the future with imagining that it's working all the time as we planned originally.
I think this bill is future-proof, but in the worst possible way. It's future-proof in the sense that the Home Secretary seeks to have power to her and her successors, through the words of the bill, to do anything they like once the universal surveillance engine is connected up to the entire national internet. So for that reason, it's additionally terrifying. The alternative would be to reset the mechanisms of surveillance and allow that there would need to be fluidity as new data sources came along, a surveillance commission, if that were to be recommended, with access to both human rights advocates and technical experts as well as senior judicial figures, could address that, and with as much transparency as possible, which is the opposite of where we are now, put forward the way that, it won't be Twitter in 6 years' time we'll be talking about. There'll be something completely new that no one has thought of now. So I don't think you can put in place a good future-proof bill, but you could put in a transparent, thoughtful, representative system of reviewing how you adapt access to intercept and communications data as the technology changes.
Mr. Redpath, anything to add finally?
No, that's perfect.
Okay, so thank you very much. We've overrun our intended time. And that's because of the interest all panel members had in hearing your point of view. You spoke with knowledge, authority and passion. And thank you very much for giving evidence today. Thank you.
Thank you.
Session. Welcome, Mr. Starmer. I'm sorry we've kept you waiting. I know you're on a tight schedule today, and I'm sure we're so grateful to have you here. And I'm sure.
maybe running, so I'm very grateful anyway.
I'm sure colleagues will also respect the tight schedule on and will be as crisp as we possibly can. Now, although we know who you are, for the public record, sir, I'd be grateful if you just state who you are and what you do.
Yeah, Keir Starmer, Director of Public Prosecutions.
Lovely. Thank you very much, sir. Mr. Ellis.
Thank you, Lord Chair. Thank you. Well, good afternoon, Mr. Starmer.
Good afternoon.
So, just to start off this session with you, do you consider this draft bill, which no doubt you've had an opportunity to study, in its present form, would allow your organisation, or the Crown Prosecution Service, to present evidence in court, where it existed, which would enable prosecution functions to be able to be carried out? In other words, would it work?
Yes, I think it would. We use communications data at the moment routinely, and it would allow us to continue to do so. So
you probably were not present in the room, but we've heard other witnesses say that in their view it simply is technically not going to be something that would work. The courts would reject it. But you say that already communications data is in use and you don't envisage problems with admissibility or relevance of evidence.
Communication data is in use routinely. From a prosecution point of view, what it establishes in many cases is, if you like, the chronology of a crime, proof of association, links between individuals. Linked with other techniques, it can establish presence at a particular place at a particular time and corroborate witnesses, etc. We use it routinely at the moment in a wide range of offences. Admissibility has not been a problem in the past. Usually the data is admissible either as real evidence or as hearsay evidence under the various statutes and criminal procedure rules. I don't anticipate that that's going to be a particular problem going forward.
Do you equate it possibly with another example that I used earlier, which might be cell site analysis with mobile telephone locations or DNA, which is that you wouldn't necessarily need to explain to a jury exactly how it is that scientists are able to extract DNA from a blood sample, but you'd have to satisfy a jury that the blood sample was obtained legitimately, that its provenance was accurate, and that a responsible scientific officer had performed his or her calculations correctly. And admissions can be made between the prosecution and defence to that effect, and are in most cases where DNA or other technical or forensic evidence is adduced.
I don't think it explains to the jury as a particular difficulty, because once this is adduced either as real evidence or business records, it's not very often in dispute.
Yes.
It's simply what it shows us that's relevant, and what we would very often do is use techniques to establish for the jury X was talking to Y at this particular time when, let's say, a consignment of drugs came in, and X, Y and Z were all talking together. We say they're the conspirators, and linked with cell site analysis, we can probably say, and they were standing in the following places when they were having the conversation. But it's presenting that to the jury is not particularly problematic, because the basic facts are agreed, and it's what you can read into it that becomes the issue. Very rarely is it disputed that X was talking to Y or where they were. It's the explanation that's given for that behaviour that becomes the issue for the jury. So presentation, I'm not saying it's never an issue, but it's not usually an issue.
So this bill deals with not the content of material, but the provenance of it, where it's come from, where it's going to, the time, the date stamp, that sort of thing?
Yes.
And therefore it can apply, to use another example, in obscene images, for example, in a paedophilia case, where that has been transmitted over the internet. One of the mischiefs that this bill would seek to redress would be that it would be possible to ascertain addresses, internet addresses, and date and time stamps and so on. Is that correct?
Any offence that we prosecute that involves the internet in any capacity usually requires us to produce communications data to show who it was that was accessing what part of the internet at any given time, and it can run through a range of offences. One example we've got on the schedule here is a harassment case establishing who it was that sent various messages at various times.
Sorry, please. Through you, no, please.
Thank you, Mark. Chairman, the point here, though, is that much of that evidence at the moment, Mr. Starmer, would be obtained by seizing the hardware, wouldn't it? Of a person's hardware, entering their property, taking their computer away, analysing what they've been doing with it. It wouldn't be about tracing material that is going across the internet live, if you like, or you know, it is actually about seizing equipment.
It's a bit of both, but a lot of it is seizing equipment, but not all of it. From our point of view, we're obviously concerned with the product and what we can establish from the product.
Right. Okay.
So, in a nutshell, Mr. Starmer, would this draft bill, as envisaged, assist you and your officers, agents and officers, in the exercise of prosecutions of serious offences in this country?
Yes.
Now,
yeah.
Sometimes get confused on this between the benefits that law enforcement agencies and prosecutors are getting from the existing legislation, RIPA, and what additional benefits they might derive from this bill if it were enacted. And I'm hearing from what you're saying that you're at the moment talking about the benefits you get from RIPA.
Yeah. I'm talking about that. That's what we've got experience of, and our concern is that we should maintain that coverage. Now, I don't doubt or challenge that there's a privacy aspect here and there's a balancing exercise. I understand that, and Parliament's got to think about that carefully. All I can say is, from a prosecution point of view, communication data is extremely useful in many prosecutions for the obvious reason that it allows us to establish who spoke to who when, quite often where they might have been at the time, and patterns of behaviour. If you're trying to prove a criminal case, that is extremely useful information.
And that's based on the existing legislation?
Yes.
Yeah. And the issue of admissibility of data, the question that we'll be driving at shortly is how, under this bill, evidence that's derived through the filtering process, how that will stand up in court. But I think we're going to come back to that later on.
By all means.
Mr. Brown, on this point before going back to Mr. Nelson.
Frightened that data held on them by various government agencies is accessible by corrupt public servants, sold on to somebody with no right to have it, but who wants it for purposes of their own. I mean, the topical example is journalists, but it doesn't have to be that. As I understand it, the offence committed by, say, a corrupt police officer in taking information from the police national computer to see whether someone had a criminal record or not, is misconduct in public office. How easy is it to prosecute the offence of misconduct in public office, and how frequently is it prosecuted?
Misconduct in public office is a common law offence with fairly straightforward elements. It's got to be misconduct that reaches a certain threshold in order to render it criminal. That would be one offence that could be used. There would be others, I suspect, Data Protection Act, Computer Misuse Act, possibly offences under RIPA itself. So I'm not sure we'd have the figures under misconduct, and I'm not sure they'd tell the committee very much if we were able to produce them, because I suspect that where there have been cases involving misuse of data, it's probably a number of different offences that we've considered in individual cases.
Do you believe the present law and the practicalities of prosecuting it adequately protects the public from the commissioning of this offence?
I think the Computer Misuse Act has, I think it was strengthened a number of years ago, and to my knowledge, it hasn't caused us any great difficulties. That's from my memory. I'm very happy to come back if it would help the committee on this, but so far as I'm aware, we haven't run into any particular problems. If someone has misused data, we've not found ourselves unable to prosecute for want of a relevant offence, so far as I can remember.
Could you ever think about it? And
Yeah, certainly.
Come back to the committee.
Yeah.
Whittaker, was it on this point before
Yeah,
Mr. Ellis to conclude?
just very quickly, I wonder if I could ask. I just seem to get to grips of what's going on in various avenues of this bill, and then I get blown away. You said that you often use live data communications from the internet, as well as historical stuff from hard drives and stuff, I think is what you said earlier on. Can I ask you then, how many cases would you say do not come to prosecution because you don't have the ability to get to the stuff that's in this bill?
I'm afraid I can't give you an answer to that question. I apologise. The reason being that if there isn't the evidence, then it's unlikely the case will ever be presented to us. We're presented with cases that the police have investigated, and therefore they present a file where they think there's enough evidence. Now, there may be cases where we'd say it would have been jolly helpful to have had a bit more of this or a bit more of that, but we don't normally have a case where we'd be able to say, if you'd had that, we would have been able to prosecute, and we don't record that. There may be some cases, I'm not saying that would never happen, but we wouldn't then record it as a case that, as it were, we couldn't take forward because there was a gap in this particular piece of legislation.
Could I ask you then, just very briefly, best case guesstimate from you then, how much extra information is this bill going to give you that you physically don't have now under current legislation?
Well, I think our primary concern is to ensure that we can continue to use the data that is currently available to us. And the concern is that it's retained and used in a particular way at the moment. If that changes in the future, and I think the evidence on this has come from the Home Office rather than us, we want to maintain the capability that we've got. But the more, from our point of view, it's a reasonably simple approach. The more people use communications and the internet to transact business and to commit crime, the more important it is for us to be able to use evidence to establish that they've done so, either when it's an offence that involves the internet itself, and we have some of those, or where it shows elements of agreement, conspiracy for other offences. So that's our concern.
Mr. Ellis?
So because you're prosecutors and lawyers, you wouldn't necessarily know. It'd be the police who would know that they can't obtain evidence against a member of a gang, for example, because they can't achieve that evidence. You would only know, or your people would only know, whether they can prosecute files that are laid before them by the police.
Broadly speaking, I mean, the police would put the file before us. Now, in big and complicated cases, there is a conversation that goes on, and we encourage it, where the police may bring a file that's got nearly enough evidence but not quite enough, and we might suggest lines of inquiry to them, but they would then carry that out. And I can envisage in the course of that discussion it might come up that they would have liked to have got X but couldn't get it.
Yes. So, and further to Mr. Brown, my colleague's Mr. Brown's question about penalties for improper use, would the offence of perverting the course of public justice possibly apply in some cases if there was misuse in the obtaining of communications data? Could you see circumstances in which it might apply? That's an offence for which there's no limit to the amount of penalty, is there, in terms of life sentences is applicable?
It might apply. It's not entirely straightforward. I certainly can conceive of some cases that might fall into the category of perverting the course of justice. I'm not sure it'd be the starting point in most of these cases, but it might be available. And
finally from me, would you say that there has been misinformation about this bill in the media? You may not be able to answer the question. I don't know how closely you've been following it in the press, but would you say there has been a misunderstanding or misinformation about it?
I'm not sure I'm in a position to comment on that. I've been following it, probably not as closely as everybody else. I've been following just at the moment quite a lot of things going on in the media. So I think I'm not particularly well placed to give a sensible answer to the committee on that, I'm afraid.
Thank you, Mr. Starmer. Thank you very much. Mr. Starmer, could you help me out here? I've heard you say about probably a couple of times today, what you're basically interested in is who spoke to who, when, and maybe where they were with the tracking information. That seems to me to be fairly basic stuff. And I think all our witnesses, including those possibly in the last panel who were quite critical of the bill, None of them objected to that basic stuff being used by the police or accessed, who spoke to whom, what, where and when. But the criticism of the bill is that Clause 1 seems to include a huge range of additional material, and logging on to internet addresses and so on, which could give a lot more information than who, what, where and when. And is it your view that you need all this extra stuff, or you basically want to ensure that whatever bill we have in the future, you're getting the basic data you seem to be using at the moment, who, what, where and when?
First and foremost, we want no reduction in the data that's currently available to us. If it's right that those producing the data may not need to do so or retain it in the future in the way they have done in the past, and that is going to impact on our ability to get that data, then that's a concern. There are some offences where what we need and what we've had access to in the past has gone beyond that. We had one case called Dark Market, which was about, as the name suggests, a covert market where you could trade in stolen goods, cloned cards, etc. And to prove that case, we needed to have a lot more information about who was actually doing what on the particular website. So there is a category of offence, website-based offences, where we need to go beyond that. But our first concern is to ensure there's no diminution in the sort of evidence that's currently available to us and is used for pretty obvious reasons when you consider what it can show.
Thank you very much. Lord Jones?
Lord Chairman, what is your experience of the extent to which internet communications data is currently adduced as evidence? Is this evidence relatively easy to explain to a jury? Do you have some views you can give us here? Juries, I think generally are not very expert.
Yes. I was alerted to the fact that there would be questions about volume and numbers. I'm afraid that we don't track on our own databases the cases where we've used particular types of evidence, and therefore I'm not able to give answers. We've given, I think, in our written evidence some examples of the types of cases, but communications data itself is used routinely. As far as internet communications data is concerned, I'm not aware of any case where it's been overly difficult to present it to the jury. Presentation is not a particular problem for us because once we've got it into admissible form, frankly, most of the time, the fact of it is omitted, and therefore it's simply for the prosecution and the defence to explain as best they can what they read into the information.
Jury is a very British thing. Are you able, just for our benefit, to try and get into the minds of the many juries that sit throughout the nation every day? No, I'm not, and I'm no better equipped to answer that than anybody else is under the current regime. What we do, though, just perhaps to give this some context, is where big cases fail, I will very often have a case review panel and walk through with the team, sometimes our team, very often our team and the police, walk through the decision-making and ask ourselves, why do we think it failed? What would we do differently? I haven't, as far as I can remember, come across a problem where we've thought it was because of the presentation of internet data communications that we've hit a problem. But that, I mean, by its very nature, that's a selective exercise. Generally speaking, you retain a faith in the jury system? Yes. Thank you.
Mr. Hubbard.
Thank you, Lord Chairman. So, firstly, can I just ask, when were you consulted on this bill? When did you see it?
I'm sorry?
When were you consulted on this bill? When did you see what it said and have a chance to talk to the Home Office about what implications it would have for your work?
Some months ago. The precise date I don't know, but I'm more than happy to share with the committee the dates on which we were asked to provide comments.
I think that would be very helpful to have a look at. Can I then ask about the admissibility of some of this, the evidential integrity? I was struck by my colleague Mr. Ellis's comparison with DNA. My PhD in the chemistry lab was exactly on DNA. And I'm sure it's something you'll be well aware of work by Frumkin and others which shows that DNA data can be faked, and this is why I think your predecessor decided not to take evidence that was entirely based on DNA. Presumably there are times when DNA evidence is questioned as to the accuracy of it.
Yes.
So one would expect the same concerns with communications data, particularly if it gets more complex.
Yes.
So currently we have relatively simple situations where most of the communications data that comes has been requested through a spot from a CSP presenting their own data, which they can be reasonably sure is accurate because it's their data they're passing on. This bill envisages that a communication service provider in the UK would be using equipment that they were potentially supplied by the Home Office to collect data as it transits through the network that actually belongs to somebody else, is laid out in a way which they're not familiar with, and is potentially encrypted in some way.
Yeah.
Do you think that would raise questions in a court, and that somebody would be able to ask, who can actually assure me that this is the data that was actually sent in the correct format?
It might do, but I think the rules on real evidence and hearsay evidence have moved on quite considerably in recent years, and it hasn't presented us with a problem so far. That's not to say it won't, and there won't be challenges just around the corner. Of course there will be, but historically we haven't run into those challenges, and the courts have been a bit more robust about real evidence and hearsay evidence than they were in the past.
I mean, who would be able to present the evidence?
Well, with real evidence, it presents itself. With hearsay evidence, the rule now is that it can be produced pretty much as a business document without a witness having to adduce it. And that's how it's done very often. And recently, the Criminal Procedure Rules Committee has changed the rules to enable that to happen a lot more easily. So, as it were, the old approach, which for many years where you'd have to have a human witness who would faithfully sign a statement saying this is how it was all recorded, has been, to a large extent, substituted with a record that proves itself. Now, I don't, nobody knows what the challenge is going to be around the corner, but I can say that at the moment, there is rarely challenge to that record.
But I think, what I'm suggesting is that that is because the record is currently a far simpler document. If I could move you even beyond that aspect of the bill towards filtering, if I may, Lord Chairman, that means that you would have a system where there is purely a black box where no individual or organisation could be sure at all that there hadn't been something that had gone wrong, that nobody would see the transitory data. You would have the outcome of a search that couldn't be verified. So whether or not you have a person presenting it, no police officer, nobody could be sure that it was correct.
We'd have to work through the practical problems. I take the point that you're making. No doubt there will be challenges, and obviously from our point of view, we would want to be sure that in any given case we could comply with our disclosure obligations, and therefore we would need to have a level of assurance about how that process worked, because we do have those obligations.
And so if I can just ask one last question, and then, did the Home Office talk to you about how this might work from an evidential basis? Did they engage with you to make sure that what they produced was something which you could use, or are you now retrospectively having to try to work out how to cope with their phraseology?
Well, the communications in detail I've had have been with my policy and strategy team, and with your permission, I will check with them what and when, so that I can present you with a full answer on that.
Thank you.
Chairman, can I just press that a little further? So you've not had a briefing with Home Office about how this filter arrangement would work?
Me personally, no.
How can you make a statement at the start of your evidence then to say you believe this bill will deliver its objectives?
Because I've read the bill and I understand how it's supposed to work, and a good deal of surrounding material and briefings, and I've talked to my team in detail about it. Okay,
and you believe that even having not seen the detail on how the filtering arrangement would work and the way it would produce material and the kind of documentation it would produce, that you believe that that would still be suitable?
I've looked at the draft, I've looked at the briefings, I've looked at the background material, I've looked at the experience we have at the moment. There may be practical difficulties, there will of course be challenges, but I do not believe, on the basis of what I've read and discussed, that there are difficulties in using, there would be difficulties using this information in the future. And if it's right that the capability under the current regimes will go down, that is something that concerns me.
Yes, just picking up on that, Mr. Starmer. I think it's fair to say what you're really saying is that there might be some challenges because of the width of the filter. The existing rules about business records, hearsay and the like might not initially cover it. At the moment, I don't think there's much issue usually with the admissibility of these records. There might be some initial challenge, but you'd expect it to settle down in due course.
Yes, of course there'll be challenge. I'd be surprised if there wasn't, but I have faith that these will be workable provisions.
The obligation of disclosure can be rather onerous. There is going to be a considerable amount of additional material. Do you envisage difficulties with potentially a sizable amount of material that you might be asked to or obliged to control, to disclose consistent with the Attorney General guidelines?
I think we will have to carefully consider how we approach the disclosure exercise if this regime becomes law. And we will have to be careful to ensure that we are taking what steps we need to take to comply with our obligations, and that we're completely clear with the courts as to what we have seen and what we've asked for and what we possess. I think that can be achieved. We've achieved it across a number of different fields where there are obvious problems.
I appreciate the context in which you can tend to see cases, but you've also told us that you will review cases afterwards. Have you been aware of this so-called data gap in the course of your work? The data gap which will potentially be filled by the obligation on CSPs to preserve data which they don't need for business purposes?
No, I don't think I can say I've seen that gap, but I am clear that the data that has been provided to us has been extremely useful, and if it's right that what is now retained may not need to be retained in the future, and thus what's available will reduce, that is of concern to me.
Do you have much experience of mutual legal assistance treaty processes? We've heard it tends to be rather a slow process, but can you help us more than that?
Yes, I mean, it's a useful, but it is a slow process. It's usually reserved for obtaining evidence after the commission of an offence where that evidence already exists in another jurisdiction. I think the difficulty here would be, first, ensuring evidence actually existed because it had been preserved in some way, because no mutual legal assistance treaty helps if it's not been preserved. And secondly, it is a rather slow process, usually measured in weeks or months. And therefore, to my mind, it wouldn't work well in this particular field.
One other point I'd like to ask you about, if I may. We've heard from the Information Commissioner who gave evidence to this committee about a tendency for police forces routinely to extract personal data from, for example, mobile phones of suspects, and then retain that data even though that person is subsequently not charged. Now, this may be a bit of an unfair question to field, but can you tell us, first of all, whether that's legal or not? Under PACE or any other provision?
I'm not sure off the top of my head. I don't know. But I mean, I could certainly work up an answer for the committee, but I'm not sure. I mean, it's not a straightforward question, and it's not one that I've considered before. And I'm sure if I have a shot at it, I'll regret it in about half an hour when somebody gently points out to me.
I apologise for asking.
I mean, but on the other hand, I'm more than happy if it would be helpful to the committee to give a considered view in writing in a pithy way.
You can see why we're interested in it.
No, I do, but I equally can see the trap that I'm obviously about to walk into if I attempt it on my feet.
I do understand that. Do you know if it's extensively done?
I don't know, but I don't think anything can be read into that one way or the other. I don't think I necessarily would know. I've not personally come across it, but then I see a limited number of our cases, and I wouldn't necessarily be privy to that if it happened. So I haven't come across it, but I really don't think anything could be read into that one way or the other.
If you could reflect upon the issue and let the committee have
Of course.
that would be very helpful. Julian, do you want to come in on the filtering arrangements?
Already covered it.
Okay, fair enough. Sorry, Lord Armstrong.
The Home Office are depending fairly crucially on the distinction between communications data and communications content. And content is dealt with not under this sort of bill, but under completely different arrangements. But the point has been made to us in the course of evidence that that's a very blurred distinction, because what you can get now about data shades into content. If you know who has been speaking to who, when and where, the frequency of conversations, you can get a long way towards content. Is this something that has concerned you or affected you?
I do understand why that point is made. I mean, a classic example here for us would be a case where we're able to say that consignment of drugs came into port X at a particular time and we think that 3 people were involved in the exercise. We look at the traffic and the communications traffic between them when we establish that by coincidence, or we would say because they're conspirators, they were in contact throughout the passage of the drugs, and when the drugs arrived they were in a lot of contact all of the time, and then it dropped off. And whilst we don't know the contents of the conversations, we are often asking the jury to imply that they must have been talking about the consignment of drugs that have just been brought into the country. Now, that doesn't give the jury content, it doesn't allow us to rely on the content, but we are sometimes saying to the jury, the only inference you can draw here is that at that time, as they were both using cell site analysis right there in the dock as the drugs came in, they were talking about the consignment of drugs. That's a classic example of when we use it.
Do you want to follow that up, Lord Armstrong? Or?
No, I think that I think you are really saying that that distinction retains validity for the purposes of this.
The distinction does retain validity. Yeah. Nothing here encroaches on content, but realistically and frankly speaking, we are on occasion inviting the jury to infer that A was talking to B about the crime that we're trying to prove.
But there is a difference between inferring something from a series of events and listening or reading the content of the communication.
Absolutely, and the classic defence in that case would be, no, I'm the godfather of his child and we were discussing what I should get for his next present.
Mr. Ellis.
Thank you, Mr. Brown. So, Mr. Starmer, the draft bill, just moving on a bit to the public authorities and who should access communications data. So, now the draft bill limits those bodies which will have a right to use the powers provided to access communications data, and all the other bodies will have to make a case to the Home Office as to why they should be included. Is that right?
I think that's right, yes.
So I was looking at the written data provided by the Crown Prosecution Service, written evidence, I should say. Now, the Department for Work and Pensions is a department which the CPS seems to wish to continue to have access to comms data.
Yes.
And this is clearly because of the work prosecuting benefit fraud.
Yes.
So how important is comms data to the work in the prosecution of benefit fraud for the DWP? Do you know?
Yes, just by way of background, if I may. The DWP obviously investigate and prosecute fraud, benefit fraud. In March of this year, the prosecution function of the DWP was transferred to myself and to the CPS. So we now, within our team, prosecute DWP fraud. So
prior to that, there was a separate prosecuting entity?
Exactly. And one of the areas in which we've all rationalised our business is that we now prosecute for some departments where we didn't before. So we now house and prosecute on behalf of DWP. And that's why it's in our evidence, because it now becomes material for us.
Right.
The case here is pretty much the same. There's nothing particularly special about benefit fraud. It's fraud. It happens to be fraud against public funds as against fraud against private funds.
Yes, but we want to stop it, though, don't we?
We want to stop it, we want to prosecute it, and the techniques and the evidence that you use for fraud on public funds is pretty much the same as you use on other funds. And our only concern was that being the case, and it being the case that DWP currently access the data, again, we didn't want to use that capability because it would affect the prosecutions we now bring.
Right. So from it would be your submission that the Department for Work and Pensions, and thus the Crown Prosecution Service, should have access to comms data in order to prosecute benefit fraud?
Well, I think all we're doing is gently pointing out that this needs to be covered in one way or another. I don't think it's really for me to say how that needs to happen, but just one way or the other, those charged with this bill, as it were, should know that DWP currently has access through statutory provision to this data and uses it, and by whatever means, if, when the bill is passed, they didn't have that capability, it would fundamentally affect the way in which we could prosecute their cases.
You wouldn't want a limit placed on that body?
No.
For that purpose?
No, the only caveat is, without studying again the detail of the bill, I couldn't say for sure it couldn't be achieved by some other means. But by whatever means, there needs to be access to that data, in my view.
Do you oppose the repeal of Section 109, subsection 2A of the Social Security Administration Act 1992?
Well, it rather depends with what it's replaced with. No, I mean, if the result is that there would be no provision for gaining access to communications data in fraud on the public purse, then yes, I'd be very concerned. If there's some sensible provision in its place, then no.
I see. Thank you very much.
Thank you, Mr. Starmer. I think we're all happy. Everyone in this room is happy to see benefit fraudsters prosecuted. It's just a matter of whether we need all the provisions in Clause 1 in order to do it. Lord Armstrong.
The list of authorities which have access to these data under RIPA is very long. 10 or 11 or 12 kinds of authorities. It includes not only local authorities, but the Coast Guards and other authorities. Do you feel that though the use that those authorities make of the powers of access are really much more limited than in the case of the police and the security services? Would you like to see that list reduced? Do you think it's justifiable to use these intrusive powers for these other purposes?
I'm sorry, I'm not sure I'm in a position to answer that, because I don't know the use that they put them to or how extensively they use the powers they've currently got. So I'm sorry, there's just a gap there in my own knowledge. I've not had any dealings myself with those bodies in this respect.
You don't prosecute in all these cases?
No, and I just, to be honest, I really don't know how often they access it and what use they make of it, and therefore I'm not equipped to answer the question. I do apologise.
Thank you.
Lord Jones, you don't want to press on the criteria? The criteria?
No, sir.
Okay, right. Lord Fox. Oh, I'm so sorry. Yeah. You did that question, or was that? Yeah. Colleagues, any other follow-up questions for Mr. Starmer? Yeah. Excellent. Thank you very much, Mr. Starmer, for coming along today, and I hope we haven't detained you too much on your busy schedule. Thank you very much.
I'll follow up on those issues.
That's right. Okay. Public would leave as we go into private deliberative session. Thank you all very much.
Sound.